Yes, today we are going to, good morning, you all. Today we are going to start the talk about two main topics. First one is possessory action. The second one is the condominium property in Sri Lanka, especially in Sri Lanka. So those two sections to be discussed, proposed to be discussed. First, I'll take the possessory action. For condominium property, I have sent you a handout. I think you may have got it now. It's a long page, 7-page one. So possessory action, no handout. You'll have to follow chapter 9 of Professor G.L. Perry's book, that is the Property Law in Sri Lanka, Volume 1. That is the place you must go to take necessary literature for the discussion. Anyway, the handout, the slides are there. I'll discuss with that. And in addition to that, you can follow the Professor G.L. Perry's book, chapter 9. All the details are there. Some additional things I'm going to discuss here today. So after the lecture, we'll have to go back to the chapter 9 of the relevant publication and collect all the details and prepare a sort of document for you to understand. Sometimes you might get a question on this at the examination. Okay. So, what is possessory action? Possess means you are possessing a certain thing, movable or immovable. That is possess. So, possessory action means if you lost the possession, how can you vindicate that, or how can you get it back? So for that, you have a remedy which is called possessory action. So we are going to deal with that. What is possession, first of all? Possession means one of the attributes of what? Ownership. We have done this early lectures. The attributes are possession, enjoyment, use, and alienation. Okay, so this is one of the ingredients or the attributes of ownership. That's no problem now. How possession arises? There are different ways. You can go and occupy someone else's property, or you can get, or you can purchase the land, then you get the right of possession there. Or sometimes under prescription, you can get the possession too. But through possession, you can finally get the ownership. There, the ownership includes again the possession. Now, what remedy is available for the possession for a person dispossessed from possession? One man was there and he was dispossessed. Dispossessed means chased out. Then what is the remedy he has? We are going to discuss that today. That is called the possessory action. Who can bring an action, and against whom the action can be brought? Those things we are going to deal with. Who is benefited by the action? So these are the cluster of the area that we are going to touch upon during the period of this discussion, this lecture or the presentation. So if you go back to Roman law, there were some remedy, that is remedy to heirs. Heirs කියන්නේ උරුමකාරයන්ට who are dispossessed. උරුමකාරයන් එළවපුවම නැවත ඒගොල්ලෝ ලබා ගැනීමට රෝමන් ලෝවල තිබුණ රෙමඩියක් ඒකට අපි කතා කරේ mandament van immunity. Then second one is remedy to persons dispossessed. A person dispossessed. Court may order to reinstate and order to abstain from future disturbance. Any person who was dispossessed, he has the right to go to courts and get the possession back. The second one. Third type, plaintiff has to prove that he was dispossessed by the defendant. You have to prove that. That is the third one, in third case. Here the remedy will be reinstatement, compensation, and restoration. So if a person can prove that he was dispossessed by a defendant, then he can get the possession back, or he can get the compensation, or restoration. Restoration means ඉස්සෙල්ලා තිබිච්ච තත්ත්වයටම පත් වීම. Then number 4 involves the time within the action should be brought. So action should be brought within a period of time. We'll discuss during the process of the discussion. Now, say for example, I am staying someone else's land. I have no ownership. Right? Can the owner come and chase me out? Owner is there. I'm going and staying there, possessing that property. Can the original owner come and dispossess me? He can't. That is law. Now, that is decided in Nino Bonino versus De Longe. It is a fundamental principle that no man is allowed to take the law into his own hands. So that is the principle. That is why even he is an unauthorized possessor, the real owner can't chase him out because he has no right under law. No one, because he can't take the law into his hand and throw him away. That can't be done. If you want to do it, we have to go to courts, take the permission, and eject this man. So that is the procedure. So we'll have to understand that very carefully. That is decided in Nino Bonino versus De Longe. Okay, now no one is permitted to dispossess another forcibly or wrongfully and against his consent of the possession of the property with a movable or immovable. The possessory action is based on this principle. So the possessory action කියන එක base වෙලා තියෙන්නේ පදනම් වෙලා තියෙන්නේ මේ principle එක උඩ. ඒ principle එක create කරලා තියෙන්නේ මේ case එකෙන්. මොකද්ද principle එක? No one is allowed to take the law into his hand and act. මේ case එකේ ඉදරන ඕනම වෙලාවකදී this applies everywhere. You can't take the law into his hand. There is a procedure, legal procedure. We'll have to follow that. Okay. So that is there. This was endorsed in Sri Lankan case. Edirisuriya was Edirisuriya. All the details are there in the book. You'll have to read it. You have to read it. Okay. Then these two cases has given a good background to base possessory action. Okay. Or in other words, that is based on the principle that no one is allowed to take the law into his hands and act. කිසිම කෙනෙකුට තමුන්ට නීති අතර ගැනීමේ හැකියාවක් නැහැ කිසිම ආකාරයක. එතකොට මේ possessory action එක පදනම් වෙනවා අන්නේ principle එක උඩ. A principle එක enunciated by two landmark cases. One case, a foreign case, Nino Bonino versus De Longe. In local case, Edirisuriya versus Edirisuriya. එතකොට මොකද්ද ලීගල් රයිට් එක තියෙන්නේ? කොහෙන්ද මේ ලීගල් රයිට් එක ඇවිල්ලා තියෙන්නේ? කිසිම කෙනෙකුව පොසිෂන් එක ඉවත් කරන්න බෑ කියන එක. You can just say. You can't just say. Section 4 of the Prescription Ordinance 1871 states that it shall be lawful any person who shall have been dispossessed of any immovable property otherwise than by process of law to institute proceeding against a person dispossessing him at any time within 1 year of such dispossession. එතකොට අපි prescription ordinance සම්පූර්ණයෙන්ම කරලා තියෙනවා. ඒකේ section 3 එක තමයි possessory prescriptive rights වලට relate වෙන්නේ. එතකොට section 4 එක තමයි relate වෙන්නේ යම් කෙනෙකුට කෙනෙකු බලෙන් අයින් කරුවොත් ඔහුට නැවත ඒ භුක්තිය ලබා ගැනීමේ ප්‍රවණතාව හැකියාව දීලා තියෙන්නේ section 4 of Prevention of Fraud Ordinance. That means process law institute proceedings against the dispossessed him at any time within 1 year of such dispossession. එතකොට එහෙම අයින් කරලා අවුරුද්දක් ඇතුළත යන්න ඕනේ මේ කේස් එකට. මම මෙතන කතා කරා number 4 එක original position එකේදී involves the time within the action should be brought. අන්න ඒකට answer එක මෙතන එනවා. It should be brought within 1 year of such dispossession. 1 year from such dispossession. ඒකට action එකක් කියනවා. ඒ action එකට තමයි අපි කියන්නේ possessory action කියලා. Shall be entitled to decree against the defendant for his restoration of such possession without the proof of title. But it's a very important point you can raise. What is that? In this case, this man is not bound to prove his title to get the possession back. If I tell in Sinhala a few words, යම් කෙනෙකු නිවසක පදිංචියෙන් බලෙන් අයින් කරුවොත් පිට කෙනෙක් අපි හිතමු ඇවිල්ලා පදිංචිලා ඉන්නවා වගේ ඉදර. right? එතකොට මාව එලවන්න අයිතියක් නැහැ. නමුත් මාව එහෙම එලෙවුවොත් අවුරුද්දක් ඇතුළත මට උසාවියට ගිහිල්ලා possessory action එකක් මගින් නැවත භුක්තිය ලබා ගැනීමේ හැකියාව තියෙනවා without the proof of title. මට කිසිම අයිතියක් පෙන්වන්න අවශ්‍යතාවයක් නැහැ. නමුත් මම ගිහිල්ලා කිව්වොත් I was in the possession and I was dispossessed by a certain person, then I can get the possession back. To understand, this is the legal background. First we talked the basis of the possessory action. Now I am talking from where this legal right came to a person who was dispossessed from possession. So that is very clear. Second part. Right. So we will have to, that is given in page 231, Professor J.L. Perry's book. All these details are there. You'll have to refer that. Page 231, Professor J.L. Perry's book. Requirements of possessory action in Sri Lanka. The plaintiff in a possessory action is not required to prove any title. All what he needs to prove is that he was in possession of the property. He has to prove, I was in the possession of the property when at the time of ousting him, the time he was ousted. So those two factors should be proved first. I was in the possession and I was ousted at the time. Sorry, yeah. I was in the possession of the property at the time I was ousted. එළවන වෙලාවේ මම ඒකේ හිටියා කියන ඔප්පු කරන්න ඕන first. Then you have to prove that I was really ousted. මම ඇත්තටම මේකෙන් එළියට දැම්ම කියන එක ඔප්පු කරන්න. I was in the possession at the time of ousting and I was really ousted by the other party. You have to prove those things. The last one, that he was dispossessed otherwise than by legal process. So this, if you can prove these three things, without proving any title, if you can prove this, the person who was ousted can prove this, he can get the possession back. It's a real interesting case, right? We are enjoying Sri Lanka also, right? Requirement of possessory action. It's a very simple thing. You have to prove the possession of in possession of the property at the time of ousting. And I was really ousted and I was dispossessed without any legal proceedings. So you can prove that you can get the possession back. That is the third thing we have to understand. First, we talked about the original possession, that no one should take the law into their hands and act. Second part, we got the legal position. That is the section 4 of the prescription ordinance. Then we discuss as the third one, the things to be proved to get the possession back. Now again, the second point is, that the first point, plaintiff in a possessory action must prove that he was exclusive possession of the property. එතකොට මම නිකම්ම මේක හිටියා කියන ඔප්පු කළා හරියන්නේ නැහැ. I had the exclusive possession. ඒක පැහැදිලි ඔප්පු කරන්න මේක මගේම විදියට මම මේක හිටියා exclusive possession කියන්නේ ඒකයි. නිකන් ඔය දවසක් ඉඳලා යනවා ඊට පස්සේ යනවා සුමානේ. That's not the way. If that is the case, you can get the remedy from the possessory action. So therefore, he must prove that I enjoyed exclusive possession. Yeah, this was decided in Abdul Aziz versus Abdul Rahim. Abdul Aziz versus Abdul Rahim. That's there in the book, chapter 9. You can read it. That is in chapter 236. This case, Abdul Aziz versus Abdul Rahim. You can read that, right? Okay. Then we are coming to the next one. In early Sri Lankan cases, Supreme Courts held that civilis possessio means something like ad dominus possession or exclusive possession. Ad dominus possession කියන අපි ස්ටඩි කරා ඉස්සෙල්ලා lectures වලදී. ad dominus කියන්නේ මගේම කියන අදහසින් මේකේ ඉන්නවා. Right? As a supreme owner. ඒ අදහසින් මේකේ හිටියා කියන එක you have to prove. Or that is called the civilis possessio. Possessio වෙන්න ඕනේ මේක. SSIO. Or exclusive possession. So, early cases, possession in early Sri Lanka or Ceylon was that you have to prove that I was there as the owner, or I enjoyed the exclusive possession, or ad dominus possession, or in other words, civilis possessio. මම ඒකට කියන CP කියලා. CP, UD, ad dominus possession, and EP, exclusive possession. So you have to prove EP, CP, UD. Both gives the same meaning, right? To be proved in a possessory action. So the action එක දානකොට අපිට මම කතා කරා මෙතන I was in the possession නිකම් possession එකෙන් හරියන්නේ නැහැ. It should be exclusive possession or addominus or civilis possession, CP. Right. So that's there. Then we'll come to the next one. Yeah. එතකොට අපි බලමු exclusive possession නැත්නම් CP නැත්නම් UD එක කොහොමද බලපාන්නේ possessory action එකේදී අයිතිකරුට නැත්නම් පදිංචිකරුට බලපාන විදිය බලපාන ආකාරය. That means we'll have to look at the way how the civilis possessio is affecting the decision on the possessory action. So court has taken different views and different decisions. Why is that? If the law is definite or there's a consistency or uniformity of law, the decisions can be in a different manner. But it's yes. Why? There is no fault on the part of the courts. Court gives the decision purely depending on the facts of each case. Facts of each case. මට එක word එකකින් වෙන්න පුළුවන් interpretation එකේ වෙනස්කම. ඒකෙදි ඒක නිසා සවි තීරණය වෙනස් වෙන්න පුළුවන්. That means court is perfect. Okay. Even though different decisions taken on the same matter, but that is depending on the facts of the given case. Macronin versus Janis. That's also there in handout. You can read that. Macronin versus Janis. Somewhere 237 or 38. You get that. 238. Read that, right? මේකෙදි මොකක්ද උනේ? A priest, පූජකවරයෙක්, was dispossessed by a man from the possession of the church, allowed to get the benefit of possessory action, and civilis possessio was not considered a must. In a case එකේදී උසාවිය කිව්වා මේකෙදි උනේ priest කෙනෙක්ව අවුස්ට් කරා නම් පුද්ගලෙක් ඇවිල්ලා. මේක එතකොට පූජකතුමා ගිහිල්ලා උසාවියට possessory action එක දැමීමේ හැකියාව සහ වරප්‍රසාද ලබා ගැනීමේ හැකියාව උරගා බැලුවා. මේකේ උසාවිය තීරණයක් ගත්තා. civilis possessio කියන එක addominus possession නැත්නම් exclusive possession එක must නෙවෙයි කියන එක උසාවිය තීරණය කරා. That means even though there is no civilis possessio, he can take the benefit of the possessory action. So this decision is positive. That means even without the CP, you can get the benefit of possessory action. So the priest was given the possession back. It's a very critical case, right? You can read that. That's in the book. Very interesting, right? Then you come to the Mack versus Baker. Estate manager was ousted from courts. But in this case, estate manager means he has entered into the possession in the capacity of estate manager. You got the point? Not as a possessor. So therefore, court said he's not entitled as there is no CP. එතකොට CP එක අවශ්‍යයි කියන එක මෙතනදී උසාවියේ තීරණය කරනවා. You got the point? අවශ්‍යුනේ මොකද? He has the expected level of possession. He has the possession in the level of an estate manager. That is his capacity. Therefore, court said, no, no, no. You are not entitled to get the uh, benefit of the possessory action. Okay. That is the second case. Then you account the third one. Pereira versus Sobana. Pereira versus Sobana, that's also in 238. Mark that and read it. 238, Sobana. Make him Lessee was ousted by a lessor forcibly. බදු කරුව බදු හිමියා බලෙන් එනවද මොකද්ද වෙන්නේ? So Lessee went to courts and said, sir, I was in the possession of this particular property, but I was ousted forcibly. Please help me. Please give me the possession back under possessory action. What do you think of this? Can he get the possession? Yes. Courts held that the lessee had the right under the lease of exclusive possession against the lessor. So we have to underline that. Lease එකදී lessee the exclusive possession එකක් තියෙනවා against whom? Against the lessor. You have to understand this very carefully. Even when you are doing the valuations for leasehold property, lessee is there. So you must understand, you should know that he has the exclusive rights to use that property. Against whom? Against the lessor. During that particular period. Right? So that's a very important fact that you have to trace here as valuers. You take this point serious. That means the lessee has the right under a lease, the exclusive possession against the lessor. He was allowed to get the benefit of possessory action. So he was given the possession back. There he said, yes, this man is having the civilis possessio. ඒකේදී civilis possessio කියන position accept කරා. Accept කරන්න සිද්ධ වුණා. මොකද හේතුව? Because he has the exclusive possession under law. Law assumes that the lessee has the right, or lessee has the exclusive possession, the right of exclusive possession against the person from whom the lease was granted or taken. It's a very interesting case, right? There are some important things that you have to underline and keep it right. Lessee කෙනෙකුට එතකොට exclusive possession එකක් තියෙනවා. You must understand that. But sometimes it depends on the various conditions given in that particular lease bond or whatever. But generally, he has this right. Then we come to the next one. Tissera versus Tissera. Yeah, that is also in page 239. Take down that. Plaintiff was a moop. Moop means the person who is in charge of a church, right? He's not a priest, he's a layman, but he has some rights or some rights to control the proceedings of the church. He's called the moopu. Appointed by the priest. So the priest appointed this man to look after his property or the church premises. And in that capacity, he kept the keys of the church, recited the prayers and received offers. Whether this man, what he did, he kept the keys with him, and he took the offerings coming from the pilgrims, right? And he has certain control on this. Okay, then he was ousted. Then he went to courts and asked the reinstatement or repossession of the church. Then we'll see what happened. Church grounds expended money on church and generally supervised the church work. It was held that at Balloon decision, He is not entitled to possessory action because he entered into the possession in the capacity of mupu, right? So that capacity is there. He is not a normal possessor. So therefore, court said he has no addimunus possession. එතන උසාවියේ තීරණය කළා civilis possessio කියන එක අවශ්‍යයි කියලා. Again, you can realize, you have to realize that, right? And therefore, is not entitled for possessory action. Well, now, up to now, there are certain things rolling here and there, this side, that side, and other things, right? Other side. So what we have to understand here is, in early cases, normally court thought that the civilis possessio is a must, but there were certain exceptions given under the case law. Alim versus Lebbe. This is regarding a mosque, Muslim Devasthana. There was a offering priest, again, Pujaka Tumek, Hitya, mosque. He was there for about 35 years. And suddenly he was ousted. Then this man went to court and said, I was ousted from the possession. I was there for 35 years. This is really unfair, so on and so. Then what happened there? Alim versus Saif. That's also a very interesting one. Because he was there for 35 years. Right? For example, in case of the prescription, if we had that undisturbed and uninterrupted possession, or what you call this adverse possession, the period is more than enough, right? But under the concept of the possessory action, what happened? Halim versus Lebbe, page 239. The plaintiff had for 35 years, right? That's there. Then he was forcibly ousted from the position. So here again, court said that for a possessory action, you have to prove the civilis possessio. And you have to prove that civilis possessio to get the benefit of the possessory action. But again, you'll have to go through. He's not a normal possessor. He was a priest in a mosque, offering priest. He's working there, and sometimes he may go out and stay outside after the offerings and everything is over. So that is the position. So therefore, court said, yes, you can't get the benefit of possessory action because you have not maintained exclusive possession of this particular property because you entered into the possession as an offering priest. That's also a very interesting case. The next one, Shankara Pillai versus Chelaya. Plaintiff was a manager of a temple, also a manager. He was dispossessed. Court held. Court held that the manager had the control over the temple and he is entitled to the possessory action. So this is a very, very, very interesting case. Now here, in certain cases, court said the estate manager, no, you can't get, right? The priest, you can't get. But here, plaintiff was a manager of a temple. Even though he is a manager, he had some control over that. He had some exclusive possession over that. Anyway, he was dispossessed. He went to courts and tried to get the benefit of possessory action. So we'll see what happened. Manager had the control over the temple. On that basis, court said he's entitled to the possessory action. In addition to that, here on one hand, the possessory, like civilist CP was not required to bring possessory action. But in this case, actually what happened was actually he's a manager. So that if I court said, yes, you are a manager, but you had some control uh, over the temple, and therefore, uh, even without civilist possession, you can get the possession back. Now, that's a certain sort of um, these things are subject to arguments. But anyway, this is the case, decided case. Very correctly, court had decided on this. Sri Prakasam versus Swami Nata. Swaminatha, that's also there. Uh, you can read it, Swaminatha. Yeah. 240, page 240. You will collect all this information and must write an essay on this. So keep it so that that's a sort of answer for the exam if you get a question of that, right? You can just leave it, you get full marks. So you have to self-study. Now under it, I gave you the self-study and write an essay which carries 10 marks. Like that in certain areas, I'm not going to give the full this thing because you all are MSc students. So you must do some work, some sort of analytical analysis of the study, right? Therefore, that is up to you. If you want to get the exam passed, you have to follow my instructions and do some additional work. Okay, then we are coming to Fernando versus Fernando. A lessee was in possession, bona fide possession. Here, actually, what happened was there was a lease agreement between lessor and lessee. But this is not a perfect one. There were some defects or the defective agreement, defective lease agreement. Some defects are there. So then this lessee was ousted. The early case we saw that there was a perfect lease agreement. Lessee was ousted, went to courts. Court said, you must go back to the possession because you have the exclusive possession under a lease. Against whom? Against the lessor. But මේක පොඩ්ඩක් වෙනස් වෙනවා. මෙතන බලමු මොකද්ද වෙන්නේ. මේක අර වගේම lease agreement is there. Lessee is in possession, right? He was ousted. Then this was taken to courts. උසාවියට ගියා මොනවද ආගියු කරේ? This man might have said, the lessor might have said that, sir, this is not a legal document. There were some defects in the agreement. So therefore, there is no actually the real legal binding between two parties. So we'll see what happened. Then court took a flexible decision and said, even though there were some defects, the lessee is entitled to the possessory action. Word we have to understand this way. Lessee was in possession, bona fide possession. He didn't know that there were some defects on that. සද්භාවයෙන් මේකේ පදිංචි වෙලා හිටියා. මේක හරි යුක්ති සහගත ලියවිල්ලක් කියලා. නීතිමය ලියවිල්ලක් කියලා. Bona fide possession. Underline those words. On that, this was taken to courts and court said, no. Even though there were some defects, this is a bona fide possessor, and he was in possession, thinking that that there is a legal document or the legal agreement between parties and legal bindings, so there, so on and so forth. So finally, court took a very beautiful and flexible decision, said the person who was ousted should be brought back to the possession, and he is entitled to get the benefit of the possessory action. So we must compare this case, this lease case, and the other lease case, right? Then only you can understand actual picture of this area. Another case, Fernand versus Fernand. Here, that is also in this book, you can read that. There was some Dobie crowd. They washed the clothes and put to dry on a certain land which was owned by, say, Mr. Fernand or say Mr. X. So the land was used for drying clothes by persons called N. So the owner of the land ousted these fellows, you must go out, don't dry the clothes on my land. So that is actually what happened. Then this crowd, Dobie crowd went to courts and said, we have been there. This is our job. We don't have any job. From this, we are collecting money for our living. And but however, we were chased out. Please give us the possession back. And what happened? Then court said, again the court accepted the CP and said, you have not established CP, therefore you can't get the possession back. Therefore, court is not going to give the possession back to that crowd. So there again, in this Fernand versus Fernando, this case, there was another case, Fernand versus Fernando, there's a different one. Yes, here, now Fernand versus Fernando, same thing. Yeah, but two different cases, right? Make a numbers, reference numbers, two different years, these two cases happen. Right, so this is the area that we discussed up to now. That is, if I come back, so we discussed the first part, the original position. Then we studied the legal background. Then the legal statutes that gives rise to possessory action. Then after that, we discuss the requirements for the possessory action. Then we discuss the three components, EP, then EP, UD, and CP. මේ තුනේම අදහස එකයි. CP එක අවශ්‍ය වෙනවද අවශ්‍ය වෙන්නේ නැති කොයි වෙලාවටද මොකක් සඳහාද to get the benefit of possessory action. So that different ideas were there, different decisions came up from courts. Then we'll try to get the final decision. Now, what is the current position of this? Professor G.L. Pieris concluded that majority of cases support the view that CP was indispensable as the foundation of relief under possessory action. So, Professor says that majority of cases say that CP is a requirement. These decisions suggest possession or dominus civilis possessio is required to claim the remedy under possessory action. That was there. However, there was some flexible approaches to the remedy. The intention of holding the property as the owner is sufficient rather than as owner. එතකොට අවසානයේදී conclusion එක මොකක්ද? What is the conclusion? We'll have to underline this. Professor G.P.'s he said that Majority of cases say that there must be CP, but in certain cases they say no. But finally he says that uh, you must follow some flexible approach. That is, the intention of holding the property as the owner is sufficient rather than as owner. උගෙම කියලා හිතාගෙන ඉන්න එකට වඩා අයිතිකාරයෝ වශයෙන් ජීවත් වුණා කියන එක ප්‍රමාණවත් කියන එක මොකක් සඳහාද? possessory action එක ප්‍රතිඵල ලබා ගන්නවා. This is very interesting but very difficult to understand, but it is there. If you understand the real meaning, that's very interesting. Intention of holding the property as his own is sufficient. Intention of holding the property as his own. Rather than as owner. අයිතිකරුම කියලා හිතාගෙන ඉන්නවට වැඩි අයිතිකරු වශයෙන්, right? There's a flexible approach. As his own is sufficient. මගේම කියලා අදහසකින් තිබුණොත් ඇති. නමුත් අයිතිකරුම මම කියන එක සංකල්පය අත්‍යවශ්‍යම නැහැ කියන එක final decision එකට ඇවිල්ලා තියෙනවා. Come to the next slide. The restrictions on bringing the possessory action. According to the section 4 of the prescription ordinance, the proof of dispossession should be 1 year before the action should be. අපි කතා කරන්න ඉස්සෙල්ලා possession එක කරලා අවුරුද්දක් ඇතුළත මේක ඉදිරිපත් කරන්න ඕන. According to the section 4 of the prescription ordinance. Early court's decision based on the plaintiff should bring the action within 1 year from the dispossession. How we are in later cases, there was some there were some changes. So that is that is enough for the possessory action. Any questions? If you want, you can ask. Now this is sometimes one might say that this is very unreasonable. Why? Because, excuse me. Yeah, one might say this is unreasonable. Why? Because outsider can go to someone else's land, stay there and get the and stay there. And he was chased out, and again the law says that he should be brought back to the possession. So from that point of view, if you look at from that view, that you think it's unreasonable. But again, there are certain things under different terminology. For example, if you take the United Nations, they say every man has a right, should have an inch to live in this world. හැම වෙනියෙකුටම පොළේ ජීවත් වීමේ අයිතියක් තියෙනවා කියන concept එකක් තියෙනවා. So under that concept, this is not reasonable, right? This is reasonable because he can stay there because no one is there. Sometimes the owner may not come over there for a long time. This was abandoned. Abandoned means at 11. Abandoned means sometimes that's a nuisance for the national economy. You got the point? A nuisance for the national economy. Sometimes there may be some produce from that land. But if this man lives and went outside for about 30, 40 years, then during that time, the income is not coming, no produce. So the national economy will be affected. So that is one side. So to prevent that, sometimes the law says, yes, you can go there and do some work, produce something or whatever. So, and after that, again, the law says, if we stayed there for 10 years, by satisfying certain conditions under prescription ordinance, you will become the one. Same principles applied for that also. That United Nations concepts and many other things, the World Bank declarations, and there are so many things that where every man has a piece of land to live. That is the accepted principle throughout the world. So if you are going to value the land, value your land, if a person is staying there, you'll have to be very careful. You must find out on what capacity he is staying there, right? Whether this man has been chased out earlier and again come back, or sometimes was there a possessory action by this man to get the possession back. Those things are very, very important for the valuers to decide his valuation figure, because there is a certain litigations and other things, the value is going down, especially for mortgage purposes. No one is going to buy that, even in a forced sale after a certain period of time as a result of default of the loan. So there are certain problems, certain things to be um, kept in mind. If any person is possessing a land which is not owned by him, so in a situation like that, we have to study on what capacity he came to the possession, how long he had been there, right? Is he willing to go out, or is he paying any rent to the owner? So you must collect all these things and you must put it in your report. That's very important. Otherwise, you say that there's a possessor. That is useless. So if you are law students now, you must look at from the legal point of view. And you must give all the details that will affect your value at the same time to the legal uh, concepts, right? Legal terminology. So those are very, very important. You have to understand, right? That is the purpose of doing an MSc course. So when you're writing a report, it should be a perfect one. It should be full of valuation principles, full of legal principles, full of economic principles. Everything should be there in your valuation report, because valuer is an all-rounder, right? Sometimes he's studying all the subjects related to land. So therefore, you must take that advantage when you are producing your outcome, professional document. So everything should be included in that. Okay. Any questions? You can ask me now. How many students are there? Hmm. Hmm.
14, sir.
If no questions, you can take down this assignment. You can take down this. Sri Lanka courts do not require a person who seeks possessory remedy to establish that he possessed with the honest belief that he was the owner. But they do require proof that such person intended to hold the property as his own. That is enough. Discuss. Reference chapter 9, Law of Property, Professor's book. Then section 4 of Prescription Ordinance. In this discussion, we'll have to write what we have discussed today. Everything should be included. And finally, you can come to the conclusions that this is enough. Possessing as is only sufficient to get the benefit of possessory action. So we have started our lectures in from the classification of things, and after that we touched upon the modes of acquisition of ownership of the property. So there we discussed so many concepts, and including the accession. Then after that we did what do you call this, deeds, conveyancing, that was completed. Then also prescriptions we have done. Then the co-ownership we did last lecture was for that. That's also completed. So again, today we started case 1, that is possessory action. For about 10 minutes or 15 minutes time, I'll discuss some facts regarding the mortgage purposes. Proceedings, I think I have sent you one document last week. You can just follow it up. So there in the general discussion, I want to tell you that if you want to mortgage a property, you have to sign a bond with the bank or the person to whom the property is pledged, right, or mortgaged. So you write a mortgage bond with some conditions. That is a contract controlled by the law of contract. We are doing that in future before conclusion of the session. Right. So under that, we have to follow that. So you take the loan and pay it up. Then finally, you get the property back. Mortgage is cancelled at the land registry. Mortgage cancel වුණා විතරක් මදි සල්ලි ගෙවලා. You have to get the mortgage එක අපි ලියනකොට land registry එකේ දිනනවා. ලිඛිතව එක දිනනවා. That is written in the books of the land registry. Then after the completion, if you keep quiet, that the bond is still there. So keep it in mind. We'll have to go to the land registry and get that bond cancelled. Then the full property is coming to you. That's the legal thing. Okay, now the proceedings follow the, first of all, when the application is put to the bank, right, before writing the bond, I'm coming to that. Then there are 3 sections in the bank. I'm talking about the banks, state banks. First, we'll have to submit the application. In the bank, there are 3 parties, 3 professionals, that is valuers, lawyers, and credit officers. So the application will be given to the credit officer. Then the legal part will be sent to the deeds and other things to the lawyer, and other documents required for the valuation to the valuation department of the value. So this is a very simple procedure. The value has to do the valuation, right? Under mortgage law, become valuation kallarena, you should know that that's a mortgage valuation governed by mortgage law. In that case, the timber value and everything will not be taken into consideration. They are the under valuation. You will do all these things. So do the valuation and submit the valuation report to the bank creditors. At the same time, the lawyers will go through the deeds and land registry reference. It decide whether the property is good to mortgage and give a loan. So that means title should be clear, at least for 30 years. That is done by the legal part or the legal division. So if the valuation report is there, legal report is here, that's okay. Then the credit officer will proceed to disburse the loan. But in case where the title is not clear, then the loan will not be given. If there are certain small defects, then the legal officer might order or propose to get the title registration, title insurance done through a insurance corporation or recognized company. So that is it. If everything is there, then the credit officer will disperse the loan. Sometimes the loan will be given on a percentage of the valuation done by you. The valuation report, there are three parts. That is market value, forced sale value, and the insurance value of the building. Having studied all these things, the credit officer will decide the amount of loan that can be given to this man. Not only that, after doing some credit analysis, income analysis, she or he, credit officer, will decide the amount of loan that can be granted to this particular man. So once the loan is given, he has to pray. Loan is given having a bond sign, right, between two parties, mortgagor and mortgagee, right? Then he has to pay the installments. If he's not paying the installments regularly, then what will happen? Then the bank will put a resolution to the director board to get the property vested in the bank. Bond එකට අනුව ඒක තියෙනවා. ඔය ගන්න පුළුවන්. Then after that, when the resolution is passed by the board, then the bank will go to the security land and try to sell that land to recover the money that was given to him. You got the point? So in that case, again, a valuation has to be done because sometimes after 10 years, the sale is going to be. The things may have changed and the value may have changed. Condition of the property may have changed. So many changes are there. So sometimes you'll have to sell a new property which was different from the property that was given to the bank about 10 years back. Then again, you'll have to sell it. However, if you sell it, you can recover money. If you can't sell it, what will happen? Then again, it is vested in the bank and can keep it. So, the sale done by the bank is called the forced sale value. Forced sale. Or you call it foreclosure sale. Foreclosure. FORECLUSUR. Foreclosure sale. That means foreclosure means that is a restricted sale, not in the open market, because forced sale means බලකර විකිණීමේ වටිනාකම. බලකර විකිණීම. එතකොට free market එකක් නැහැ. The price will be lower than what is expected. That's good. Right. So if the land is sold more than what is required to the bank, the balance will be given to the mortgage job. So that is the end of that. So this is the general procedure of that. You can sometimes, if I have time, I'll try to do uh, some details about the legal side on this. But for today discussion, I think this is enough for uh, this. Right. Another thing what I want to stress here is that mortgage bond should be registered in the land registry and it should be done under section 2 of the prevention of fraud ordinance. നമുക്കിതിനകത്ത് immobile property transaction act ആണ്. അതിലും it should be governed by the prevention of fraud section 2, right? Make section 2 for a valid sale, purchase, transfer, mortgage. Mortgage otherwise that will not be a valid mortgage. Okay, so we'll take about 10 minutes or 15 minutes break and come back. All right, you can have a tea and come, right? 18.
සතර මහා දිවයිනේ මිනිසුන් අරගෙන බොහෝ
මේක අරගෙන දුක. මේක දාගන්න ටික.
කවුරුනේ ඔය ඉතින් මිතුර අගත්තේ
සිසර් good morning. කෝ ඔයා අරක තියලා යන්න ආවේ නැහැ නේ. සීට දෙනවා කිව්වට. වැඩ තියලා ගියයි නේ. හරි හරි. right. මේ සිසිර අර තාප්පේ ටිකක් හීනි මේ මේකක් වගේ ගිහිලා තියෙනවා. ඒ කියන්නේ කුලන් ඉරක් වෙන්න ඇති නේද? ඒ චුට්ටක් එකක් බලන්න. එන්නකෝ. එන්න. හරි හරි. Hello, Ranjana.
ඔව්
Hello.
සර්. ඔව්
මේ
සර්.
කොහොමද මේ මගේ හෑන්ඩවුට් එක හම්බුණාද මේ කොන්ඩොමිනියම්
හම්බුණා සර්. උදේ සර් දාලා
හම්බුණා නේ මම ඊයේ PDF කළා එකක් එව්වා. හරි හරි.
ඔව් සර්.
මේ ඔව් ඒක හරි. එතකොට මේ තව කියන්නේ ඉතියේ මේ රයිට් මම පස්සේ කතා කරන්නේ එහෙනම්. පටන් ගමුද එහෙනම්?
හරි සර්.
Shall we start? Yes. Okay, now you have to follow the condominium property law. That's a very, very important topic today. Condominium property. In this discussion, I'm going to touch upon the objectives of the presentation is to identify that the what is condominium. That's not in the slides, but anyway, I'll give you. I have given you all the details in that particular this thing, right? So you can read it very carefully. All the details are there. Some additional details I might give you so you can note it down. So, yes. Identify what is condominium property. And so that is also, on one hand, a mode of acquisition of ownership, condominium property also. Under condominium law, can acquire the ownership of land. So that's also sort of not direct, but indirect method of acquiring ownership of property. Then we have to understand the nature of the condominium, nature of interest of the condominium. Why? Why it's important? Because you are valuing the interest in land. So therefore, you have to understand what is the interest in this particular land from legal point of view. What is the legal interest? You have to understand very carefully if you are going to do a good valuation of this property. Right. Then we are going to understand that. Then components of condominium. What are the components? The types of developments. There can be vertical development and horizontal development. We are going to briefly discuss on that also. So, in a nutshell, factors affecting the valuation of condominium property will be the share value. If you want, you can take this down. I'll go into that in details. Share value. Factors affecting the valuation. Condominium property. Share value. Common elements. Servitudes. Accessory units. ACCESSARY. Accessory units. Next one, the location. And conveniences. So those are the few things that has to be considered or that will affect the value of condominium property at large. So the keywords I'm going to discuss here today are condominium, common element, accessory unit, servitudes, and share value. So those are the keywords that we are going to discuss today. We can see in the handout. That's not together, but there are in certain places of this handout, you get all these things. There is a long handout with comprised of 7 pages. Okay. Now, the main statute that establishes condominium property, that is called the Apartment Ownership Law. Page 1 එක බලන්න. applicable law කියන එකේ තියෙනවා. Apartment ownership law number 11 of 1973, and there is another amendment. ඒක නම් ඕකේ නෑ, ඔයාලා ලියාගත්තා නම් හොඳයි. Amendment Act number 45 of 1982. Act number 45 of 1982. So there are certain minor amendments after that. So these two are very strong statutes that you have to study. Okay. Condominium development in Sri Lanka on different conditions. Although main market determinants of demand and supply, and in addition, there are other factors affecting the condominium development. They are personal attitudes, urbanization, first para, right? And applicability of law within the country. And principally, when land is in excess in supply, and the development of condominium properties will be on law side and vice versa. So that means now you can understand, if the land is available in plenty, there will be less chances to develop buildings on condominium law. Why? Because you can have this horizontal development, right? Then if you take a village area, normally the popular plot size will be 30, 40 perches. In that case, no point of having 2, 3 stories. But you can have a horizontal development. There are two developments, vertical development and horizontal. But in this case, horizontal development is because land is there. In a town, they have only 20 perches. If you want to develop it, so you can just put one floor and complete. Why? There are two reasons. First reason is there is no highest and best use of the land. Because land can be developed by some more floors. Say, for example, 3 floors or 4 floors. That is the highest and best use. So therefore, this man will construct at least 3, 4 floors in that particular 20 perch land. So that is how the development of condominium property varies. You can understand. Right. So that's another thing is personal attitudes. Still, most of the people in Sri Lanka like to live in the ground floors. They don't like to go up. So that is the attitude. That is why these condominium properties are less popular in Sri Lanka. But even the land is not available in, what do you call this, urban areas, say Colombo, all high-rise buildings are coming. Sometimes it goes beyond the limit of the highest and best use. So that depends on the demand of that particular development or the property. So that's a different thing, economic side. But anyway, then under this condition, high-rise buildings are more viable in town areas. Rural areas, land prices are low, and single-story horizontal buildings are preferred. Another condition that rural societies do not like to live in congested buildings. As a result, more condominium buildings are found in cities' column. So that's a fact. So what is the meaning of condominium property? You know the meaning of dominium. අපි දැන් හැම වෙලේම කතා කරනවා dominium කියන්නේ. සුවයිතිය. CO means CON means sort of co-ownership. The condominium means that is very close to the co-ownership features. All right. So in the Condominium Act, they have given the long title. You have to read it and understand. Onam Act got a long title. That is the intention of the act. You got the point. But in this case, they say you provide registration of title of condominium parcel, building, subdivision, amalgamation, so on and so forth. You can read that, right? So what is dominium? It's the supremacy of the ownership. Condominium means a block of apartments, each of which is owned by an owner. So condominium property agattama, that's common. No one can say the entire building, land and building is his. He has only one unit or 2 units of a particular condominium property. Got the point? So that is sort of restricted ownership. He can use that particular unit by using certain other common things like stairway, garages, then car parking areas, passages, so on and so on. Those are common things which are called the common elements. He can use that, but he can't own it. For example, staircase is a common element, and one co-owner cannot own that, but he can possess it. So that's the difference you have to understand here. For the dictionary meaning, a building containing number of individual owned flats. Apartment means a flat with a set of rooms. You can read all this, right? Condominium property. You can read that, right? So there are 3 types of condominium. 3 types of condominium. First one is erected on alienated land parcel and capable of being subdivided into parcels is called the condominium. Condominium can building එකක් ගත්තාම මේක බෙදීමේ හැකියාව තියෙන තත්ත්වයෙන් ඉදි කරනු ලබන building එකක්. So that is called condominium property. Erected on alienated land. විකුණපු ඉඩම නැත්නම් අයිතිය ලබාගත් ඉඩම. Second type, proposed to be erected on alienated piece of land held as one land parcel and capable of being subdivided into parcels is called the provisional condominium. First one is condominium, second one is not yet developed, but it can be developed by the building, storied building, multi-storied building that is not yet erected. That is called the provisional condominium property. Third one, partly erected, on alienated piece of land held as one land parcel on which there are one or more than one story and having more than one completed condominium parcel fit for human habitation is called semi-condominium property. Semi-condominium means halfway completed, but at least one unit is habitable. That is called semi-condominium. So there are 3 types: condominium property, normal condominium. Then second one, provision, not yet done. Third one, semi-condominium, halfway done, but partly completed to the level of human habitation. So these 3 types are there. When you are valuing the land for the condominium property, you must understand under which category this land falls. Okay, those are the types. Condominium law envisages the following among other factors. එතකොට ඔයගොල්ලෝ අරගෙන බලන්න මේ මම දැන් කියපු acts දෙක. පළවෙනි 73 act එකයි ඊට පස්සේ 83 වල ඒකට තියෙන amendment. ඒ දෙක අරගෙන you have to read. If you are going to do a good valuation or any development in condominium property, you will have to be very conversant with these two acts. One act and the amended act. Right. Law envisages the following among other factors. One, survey plan to be prepared. එතකොට අපි සාමාන්‍ය survey plan එකක් නෙවෙයි. Under condominium property, there is a different type of survey plan. Condominium survey plan. Right? If you take one unit, there are how many boundaries? 6 boundaries. In normal land, they have 4. In addition to that, the condominium plan, top and bottom. Right? Zenith and bottom. So, one of the differences will be that 6 boundaries in one particular unit. So the survey plan should be prepared for that if you want to do a condominium plan. Ownership of individual unit by separate owners. So once the survey plan and the deeds are registered in the land registry, then ownership is given to a unit owner. එක යුනිට් අපි යුනිට්ස් 10ක් තියෙනවා මේකේ තට්ටු දෙකේ පහ පහ. එතකොට උඩ තට්ටුවේ අපි හිතමු යුනිට්ස් 5ක් තියෙනවා නම් ඒ පහේ යුනිට් ඕනර්ස්ලා 5 දෙනෙක් ඉන්නවා. මේ 5 දෙනාට වෙනම ඩීඩ්ස් 5ක් තියෙනවා. So if you are valuing that, you have to go there and get that particular deed. That particular deed and do your valuation. And in that deed you have to read and see the conditions and other things that will affect your valuation. Individual separate. Possibility of allocation of separate sections of property to such individual units. So, now I'm going to the section 3. Yeah. Section 3, first of all, I'll talk about the common elements. That is very important. What are common elements? Normally, the common elements will be චතුරිකා ඉන්නවද? චතුරිකා? Not there. මధుරි චතුරිකා නැද්ද? ආපුවා මට කෝල් කරන්න. Right? Right. Now tell me, what are common elements? What are common elements? Example? Yes, Madhuri, කියන්න බලන්න. Have you seen condominium properties?
Yes, sir.
Yeah.
Open spaces,
Hmm.
general areas in condominium properties.
Yeah. Now, I'll describe it this way. Now, you want to value unit 5 of the upper floor. You have to value it. Unit 5. So, you have to find out in the particular deed, what are the common elements available to that particular property or the unit. So, the common elements will be sometimes stairway. Can be commonly used, but you can't own it. Passages, Then parking area, common parking area, you can use it. Then what else? Then you can have a sort of open space. Put them into that you can use it. What else?
Gym areas,
Pardon?
gym.
Yeah, that's correct. Like
Gym.
that, there are so many things that you can use. Good. Okay, so with those common elements, sometimes value is going up and down. That is obvious. So you have to be very careful what are the common elements that particular land can enjoy, or that particular the unit owner can enjoy. One thing. Then another common element is the foundation of the building. It's common to all as far as the construction is concerned. Columns, right? Then beams, they are commonly used, right? Slabs, commonly used. So those things are also considered common elements as far as the construction arena is concerned. Understood? Okay. So that can be construction side, other physical factors, sometimes amusements or enjoyment, right? So on and so forth. Okay. Then, for example, sometimes it might say this unit 5, man has no right to use the parking area. That is given to certain people, unit owners. This man has no right. So what will happen to the value? You have to concern about that. So there are so many things you have to understand as far as common element is concerned. Right. Normally, when it comes to common elements, page 3, 1 CE1 means common element number 1 in lot 1. ඒක තමයි symbol එක හඳුන්වන්නේ. 2CE2 කිව්වොත් common element 2 in lot 1. Right. So that is the symbol. Right. When we are coming to the accessory units, the same page, what are accessory units? Accessory means, now say I am the owner of lot 5. I have a special right to use one particular car park. Others can't use that. That is an accessory unit for me. That is called the accessory. That is not a common element. That is an accessory unit that only I have the access to. Understand? So, when you are valuing the property, you must see whether this particular man has some accessory unit. You have to understand that. That is outside the unit. Right? Outside the unit. Right. Accessory unit එක අපි symbols මොනවද page 3 එකේ බලන්න. අපි දැම්මොත් A1A stroke FO U1 A1. ඕක දැම්මම ඕක තමයි තියෙන හුඟක් වෙලාවට plan එකේ. ඒකට අපි දැනගන්න ඕන අඳුරගන්න as valuer or property developer or whoever the professional is. That is lot 1 in building A. Lot 1 in building A. In ground floor. Floor කියන්නේ බිඳුව කියන්නේ floor 0. Ground floor. For unit 1. Unit 1 එකට තමයි ඒකේ accessory unit එකේ අයිතිය තියෙන්නේ. A1 means accessory 1. the ground floor, unit 1. Okay. Then we are coming to the next topic, subtopic, that is servitude. Servitude වලට අපි වෙනම lecture එකක් කරනවා පස්සේ. Now make a servitude within condominium property. Right? Although we call this condominium, the real technical term is the apartment ownership law. Right? That is the technical term we have to use it, right? So under apartment ownership law, what are the servitudes that parties can enjoy? Servitude means paravashyata කියන අදහස මම මේ කතා කරා ඉස්සරහ lectures වලදී. For example, if you have right of way to come to your land over someone else's land, that is servitude. paravashyata. Right. ඒකේ දීලා තියෙනවා some servitudes. That means some other person can use it. Under that servitudes වල එනකොට there are two tenements, two persons. First person is the dominant person. Second one is the servient person. මම මේක පස්සේ කතා කරනවා. Dominant person කියන්නේ who can get the benefit of the servitude. The suffered party is the servient party, servient tenement. So that is given in the section 31, section 13 of the apartment ownership law. Section 13. Section 13 එකේ දෙනවා. 13 1 2 3 4 5 6 කියලා දෙනවා. ඒකේ first එක තමයි you must give the lateral support to the adjoining landowners or the unit owners. Number 1, මේකේ තියෙනවා ඔන්න කෙටියෙන් ලියා ගන්න 13 1. You must give the lateral support to the other unit owners. අපි බිත්තියකට support එකක් කරන අපේ building එකේ අනිත් එක්කෙනාට ඒක අපි දෙන්න ඕනේ. That is lateral support. Second one, lateral support to the common elements. සමහරට we'll have to give the lateral support to the common elements. Number 3, dominant tenement should be allowed to enter into the unit of servient tenement. SERVIENT, servient tenements unit. අපි හිතමු ඉලෙක්ට්‍රිකල් මොනාරි ෆේලියර් එකක් කළා හදන්න අවශ්‍ය නම් ඒකට ඇතුළු වීමේ පරවශ්‍යතාව අයිතියක් එයාට තියෙනවා. The third one. Then fourth one, every unit owner, that is 4, has power to get the shelter, from other units. Number 5, dominant tenement has power to enter into another unit to do repairs to the shelter. Number 6. Servitude to passage. Servitude to passage of water, storage, drainage, and electrical power. කියන්නේ වතුර බට ඒ වගේ AC ducts නැත්නම් storage බට ඒවා යැවීමේ servitude අයිතියක් අනිකුත් අයිතිකරුවන්ට තියෙනවා. Number 7. Right to get the light, and ventilation to a unit. To a unit. ඔයාට යුනිට් එකට එන ආලෝකය නැත්නම් වාතාශ්‍රය වගේ දේවල් හිර කරන්න බෑ අනිත් අයට. ඒක කරනවා නම් ඒකට ඒ බලපාන අයිතිකාරයාට පුළුවන් ඇක්ෂන් ගන්න. ඒ කියන්නේ ඒක සර්ටිෆිකේට් එකක් තියෙනවා. ඒක කරන්න බෑ. Like that, there are so many things you can read other things also. Yeah. So those are the servitudes. That is the 4th one. So up to now we discuss the type of condominium and what are the effects of condominium components and the interpretation, the definitions, and especially the common elements, accessory unit, and also we discussed the servitudes. Another thing is the share value, SHRE value, share value. එකත් බලපාන valuation. That is given in the deed. Share value means for a particular unit, they have allocated some percentage value from the entire property. So that is normally given on the floor area of that particular. මුළු floor area එක 1000 තියෙනවා නම් මේක 2000 නම් ඒකේ percentage එක තමයි මේකේ share value එක වෙන්නේ. That is also another fact that has to be considered in working out your valuation figures. Yes, so as far as the servitudes are concerned, there is also impact on the real value. The servitudes are more, then the value is normally coming down. That means a sort of restriction or involvement by others, then the value is a bit low. So this is identified as a cluster of ownerships. Cluster, pokura of ownerships. Cluster of ownership. No, not by only one, the sole ownership. It's a cluster type. One corner is within that cluster. A pokura inno, now he can use only that. A pokura thera anithya paවිච්චි කරන්න බෑ. So that is the restriction. Cluster of ownership, you can see. And there are also, again, there are certain things that I discussed, affects the value of that particular unit. So now, yeah, when it comes to the ownership and the interested parties, I don't know whether it's there. We'll see. Can remember that it was there. If it is there, we are lucky. It's not there. Must be in a separate one, I think. If I find it out next time, I can show you. No, it's not there. Anyway, now ownership and interested parties. If it is a freehold, the one man, the supreme owner is the owner. Leasehold එකගත්තොත්, what are the parties? Lessor and lessee. Right. Then life interest ගත්තොත්, the real owner and the life interest holder. Right. Ownership එකගත්තාම owners. Then when it comes to condominium property, co-owner, that's in page 4, unit owner, it is a mixture of ownership and sole ownership. So you have to understand that. You can have a definite demarcation as far as the ownership of the condominium properties are concerned. All the others you can say. When it comes to condominium, that depends. The sort of co-ownership, sometimes some features of the full ownership. So it's a mixture of that. That is why I mentioned this as a cluster of ownership. So that is the interest that we have to identify when you are doing your valuation for this. Okay. Right. Now, who is handling this body or the condominium property? Who is managing this? For this, from the Act, the power is given to form a society called Management Corporation, that treated as an incorporated body, that has a legal interest. Right? Management Corporation. So Management Corporation has to control all the activities of this particular condominium property. Right. That is given in page 4. You can just read it out. Management Corporation in relation to any or more completed subdivided buildings shown in condominium plan, and any one or more party completed buildings. So that's then condominium management corporation. The co-owners or the owners, unit owners, get together and form a corporation. So that is why I said that the cluster of ownership and sort of co-ownership. So all get together and form management corporation. And by that, their property is managed in common. Say, for example, if I want to, I'm a unit owner, I want to sell my property or mortgage that, I'll have to get the permission from the management corporation. I can just do that. And all the repairs and necessary improvements to the building will be done by the management corporation, or the unit owner can do it only with the permission of the management corporation with the approved plans. That type of powers are being enjoyed by the management corporation. Right. Then there is another society called the council. So there are two societies. First one is the management corporation, the highest one. The second one is the council. Council means that there are there are members elected to that particular council. That is, number varies from 3 to 40. That's given in the handout. You can read that. And so that council also engaged in the management of the building and its condition. So that is unit. All the details are there. You can read all those things. So you can see that all the administration work will be done by the management corporation. All the functions and their duties are given in the handout and also in the this thing. You can read that, right? So the management corporation maintain a good state of repairs of the building, fixtures and fittings and everything of the condominium property, and used or capable of being used in connection with the enjoyment of more than one condominium parcel or common elements. Prevent the erection of any unauthorized construction by any individual owners of the condominium parcel contrary to the approved building plan and condominium property or semi-condominium property. So when the building is constructed, no one can change that. No one can change that. So that is up to the operation to maintain that and have a sort of control over that. Then request and assist condominium management authority or urban development authority or any local authority to remove all unauthorized structure. Now, when it comes to the condominium management authority, so that is the top one. Then that is coming under housing department or Ministry of Housing. So there is a full management that is called the condominium management authority. ඒක තමයි ලංකාවේ ඔක්කොම තියෙන management what do you call this apartment ownership or the condominium properties are being managed and controlled. So that office is in Colombo. So then after that we have within the site we have management corporation and the council. Now you can see the hierarchy. Right? So if you want to get some problem solved, you have to come to the management authority. Otherwise you can't do it. Now, for example, if you want to make some changes to the building, condominium building, then we'll have to get the approval from the management corporation. Then the management corporation refer that to the management authority, condominium management authority, or any other relevant authority to do any alteration or changes to the existing building. Then next one, where applicable, the corporation shall establish, maintain suitable lawns and gardens on the common elements. maintain repairs and renew storage. So those things they have to do. So how can they do that? Where is money? There is another fund called the management fund. So the unit owners have to contribute to that. That fund is there. So the management corporation is the sole authority responsible to expend that money. So that is deposited in a bank. So every month or so, the unit owner has to contribute. Now you can see it's something like a rented house property. You have to pay something for that. But that is for their benefit. In other cases, the rent is paid to the landowner or the landlord for his benefit. But in this case, what is the difference? The unit owners pay their contribution to the management corporation to have a fund called management fund, right? So if the fund is strong, then you can do all necessary improvements and update the repairs. Well, so what is the outcome of that? If the management fund is okay and the repairs are being done well, the value of that condominium property is going in. Otherwise, what will happen? No contribution by the unit owners, no management fund, very small amount, no repairs can be done, no renovations can be activated. What will happen? Value is going down. So in Colombo, you can visualize two types are there. There are well-managed condominium properties and sometimes the government-owned condominium properties. Rajavathyam samara thengal, they are given to the government officers. What will happen? It's very difficult for them to pay such a big amount of money for the management corporation. Therefore, the fund is coming down. No repairs, nothing, no upkeep, no renovations. What will happen? Building is depreciated very fast. The value of that particular building is going down. You got the important thing that you have to highlight here. If you want to have your building in a good state of repairs, you have to contribute. Otherwise, it will come down. But in case of normal building, tenanted building, this man will pay money to the landowner or landlord. He may not do repairs, but this man has to bear all these things by paying that particular rate. So that's the difference. But in this case, you are paying something and you get the reward. Value of your property is going in. So if I ask a question, is there any consistency in the what do you call this in the variation of the values of condominium properties in Colombo, for example? You have to answer it. Yes or no? No is the answer. So I will have to reason it out. Why? If I ask why? Why? Because poor funds, because of poor management funds. So fund is poor, value is coming down. Then the level of level of occupants, so the unit owners is coming down, and everything is going for negative. But if you are paying well in Vellath and other places, there are very well maintained condominium properties. This is coming under the property management or building management. So part of the valuation. Excuse me. Right, okay. Yeah. So answer is no. The reason is that. Reason is the building management. This is a part and parcel of the valuation. Building management and facilities management is a different one, but property management is coming under property management. The condominium property is managed well. What are the outcomes? So if there is no proper management, then what are the results? We have to analyze those things, right? So there are many duties vested in the owners of the condominium property. What are their duties? As we discussed earlier, can summarize like this. The owner shall permit corporation, management corporation and its agents at all reasonable times and on reasonable notice being given, except case of emergency. So in a situation like that, the owner has the duty to allow other parties to inspect the property, inspecting the unit. Second one, maintaining, repairing, renewing sewers, pipes, wires, cables, ducts, air conditioned ducts, used or capable of being used in connection with the enjoyment of any other unit or common elements. You can understand that, right? And third one, maintaining, repairing, and renewing the common elements. Then execution of any work or doing any act reasonably necessary for the connection with performance of its duties or perform its duties or enforcement of these by laws or by other laws affecting the building. Carry out all work ordered by any government, public or statutory authority in inspect of his unit at any time. Repair, maintain, and those things. So use, enjoyment, and so on. In addition to all, he has his duties. That's not there. To pay or contribute to the management fund on time. That is his duty. Sometimes otherwise, if you are not paying, other unit owners also badly affected. Say there are 5 units, right, or 10 units. 3 of them are not paying. Then the management fund is poor. So the repairs of the entire management or the condominium properties badly affected because the fund is low. Not to the fault of the other 7 co-owners or unit owners, but because of the non-payment of these 3 unit owners. Now you can see how others were affected by the fault of these people. So that type of thing also there happening in these things, right? In the other way also same. Sometimes 7 are not paying, 3 are paying, but 3 unit owners are badly affected because of others. So therefore, this is a sort of collective responsibility of the unit owners to do their job as designed. Right. Right. Then again, the owner should not do these things. Use fuel or anything which may be injurious to the reputation of the building. Because one owner should not use any fuel or anything that is detrimental to the detrimental to the reputation of the building or reputation to the owners, other owners of that particular building. Or sometimes to the stability of the building too. Sometimes he may use in certain things that will affect the stability of the building. So that is also restricted. And the use of fuel or any material which may give rise to smoke or fumes of, sometimes he might liberate certain what you call this smoke or obnoxious smell. So that is called a nuisance actually. අපි nuisance යන පාර කරනවා ඉස්සරහට. මේක nuisance එකක් වෙනවා අනිත් අයට. So nuisance should be abated. That is the right or the duty or the responsibility of all the co-owners to maintain the healthy condition of this premises. That's there. Then throw or allow to fall rubbish and like on the common elements. So we'll have to maintain the cleanliness. They keep any animal in his unit, which may, those things are very necessary, right? Important. In the summary, you can say condominium property is a developing concept with high popularity in Colombo and urban cities. Law has a close relationship between the real estate development and the valuation. In case of condominium properties, the apartment ownership law governs such properties. It has been imposed to safeguard the rights of unit owner and allow others, the co-owners. Example, servitudes. Law specifies the importance of common elements and other benefits and the right to enjoy them. Although the ownership is comprised of rights, enjoy, use, and possess, and alienate the ownership under condominium law has regulated some right to a certain extent. Read the act. You can read the act and see. Real estate valuer has to be much concerned about interest in common condominium property with special reference to share value, common elements, accessory units, and servitudes. So that is a very important thing included in the summary. So what type of things you could propose to improve the problematic areas that I discussed now? Management fund coming to a bad position due to the non-payment. So what we have to do is to increase the management fund. What can we do? So sometimes we'll have to go through the act and see whether they are allowed or not. But you can propose, if I ask a small question, as a valuer or a land economist, what can you propose to improve the condominium properties in Sri Lanka, especially in Colombo? So I discussed many problems, right? So by having that in mind, you have to answer this question. What can you do? Business or money earning, right? කාට යෝජනා කරන්න පුළුවන්ද මොකක්? right? සමරකෝන් නැද්ද? Samarkawan is there, no?
Yes, sir.
Yes, I can see you now. Can you propose anything to improve the current condominium properties in Sri Lanka, especially in Kalam? We discussed many shortcomings. First is the money. Second thing is the carelessness of the owners. Right? So for that, you must impose some other piece of restrictions by law to keep all the co-owners or the unit owners intact. You must not destroy this building. You must love this building. Sometimes the common elements will be neglected because that is not owned by him. The unit owner is concerned about his unit. In case of common elements, he is not bothered. Sometimes put rubbish there and some what do you call it, some type of destruction will be done by him or one unit owner. So that type of things are there. So first thing, you must introduce some system of law to be followed by the unit owners to keep this building in a good condition. And second one, the unit owners should be forced by law to pay their contribution on time to the management corporation. ප්‍රශ්න ගොඩක් ඇවිල්ලා තියෙන මේවා ඉන්නේ. එකක් carelessness එක, අනිත් එක not paying the money. They are not bothered to pay the contribution. They don't know in the long run they are losing. Their building is coming down. The value of the building is coming down structurally and economically, every aspect negative. So these fellows don't consider those things. So therefore, I propose you must conduct some seminars or workshops to the unit owners to make them aware the importance of keeping this building in good state of repairs by paying their contribution or by giving their contribution to the management corporation. And also they should be educated that if you are not paying, you are badly affected at the end of the day because your building is coming down. It will be very fast depreciation. There will be very fast depreciation. That will affect you in turn. So those things these fellows do not know. So therefore they should be educated on this by having some seminars, workshops and everything. So that's also another thing. Their mentality should be changed. Now they think the common elements are not there. So therefore they are not worried about that. Let the management corporation to maintain that and keep it at a high level or whatever. So therefore that is also another thing. You must give them a brainwash and way of thinking in terms of the condominium property and its survival. Then what are the other proposals you can make? If it is very close to or adjoining a main road, you can start some sort of sales center or whatever. You can sell some money, some items and collect some money from that and strengthen the management corporation fund. Right? That's also a very important thing. And what else? When I was talking in the class about this, one student said that, so we can have a lottery system, lottery act, right? That type of things you can do. within the premises or outside the premises, and you can sell the tickets and collector. And this is for the management part. Then also you can have some what do you call amusements, some get together, right? And that also improves the social and what do you call this psychological facts, get together. And at the get together also you can collect some money. And there also you can have a lottery or tickets by selling tickets for this thing. Like that, they can collect some money as far as the finance. So in the discussion, I introduced two parts. That is the brainwash or the psychological aspect and the monetary aspect. So those two aspects should be improved by various means. Then you can have a very good condominium property one day, right? So that is, those are the proposals that you can. So take down this question. What do you mean by condominium property? What are the statutes involved? What are the statutes involved? In relation to apartment ownership law. Apartment ownership law. What are the factors? What are the vital factors? What are the vital factors that would affect the valuation of a condominium property? I discussed all these things in the discussion, the presentation. Then highlight the defects that will be identified in different types of condominium property. In different types of condominium property in Colombo. What proposals can you make what proposals can you make to improve the condominium property in Colombo City? So you go home and collect all the details from the statutes, hand out, and from the internet, there are so many important things. Collect them and write a good essay and keep it with you. Right? That's enough. So from the today's lecture, you have nothing more to study if you do this today itself. You can keep it. That is one of the answers for the examination, maybe. So that is how you should develop your knowledge and okay. Then the finally, next time we may have a physical presentation and lectures. I hope so. So next time we are going to do very important topics, servitudes, and maybe what do you call this, environmental law and their effects on the professionals like valuers, surveyors, and quantity surveyors and engineers, so on and so forth. So that's very important. So if you can get ready and come. What do you call this, environmental law and the servitudes. Servitudes, Professor GLPs have a different book on this. If you have time, you try to read that, or else you can get some information from Google or internet or whatever and collect some information and come. Then you can follow my lecture very easily. And also at the end of the day, you can write an essay and keep it. So that's enough. Now, that's my way of teaching and advising the students for their betterment. Okay, so that's enough for the day. I'll conclude for today. So we'll next time, we'll meet next time, next week. Until such time, I'll wish you all the best. And thank you very much for your attendance. Okay, thanks a lot.
Thank you, sir.
Thank you.
Thank you, sir.